But 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Oh, please.
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate. And,
You are Lawrence Bazil. Good morning, Mr. Bazil. So I see here you've picked up 2 new cases. You've picked up a violation of a protective order or bond condition. You've also picked up a burglar of a habitation. It's alleged that on November 26th of this year, you've picked up these cases. I have no idea what's happened with these cases. Your lawyer's here with you. She's on Zoom. Please don't say anything at this point. I just want to find out what's going on because I don't know. So we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Witness stated on August 29th, 2024, he and his girlfriend, the complainant, were home when the defendant appeared at the front of the property and told the witness that he wanted to kill him or kick his ass.
Okay, hold on. You're going way too fast. So who's at the home?
So the witness and the complainant are dating.
Got it.
And the defendant appeared at the front of the complainant's house.
Okay.
Told the witness that he wanted to kill him or kick his ass. The
Okay.
defendant proceeded to walk towards the front door of the house and enter the home without consent. The defendant then grabbed some keys from inside the house. The witness ran outside of the home and the defendant chased after him. The defendant began to hit the witness several times with fists. The defendant then snatched the witness's cell phone and ran out of the house. Complaining witness has an active 5-year protective order against the defendant that was issued on 12/6/23.
So that 5-year protective order is against the witness.
The complainant. Yeah.
Okay, it's a
So the
complainant.
complainant is the girlfriend, and that's the VPO. And then there's also the Berghaus, but I mean, it's the same complainant.
The complaint is my mother.
Stop. Don't, please.
Hold on, Mr. Bazil.
I mean, really, just now's not the time. There will be a time, now's not it. So what problem did you have with anything, Ms. Oko? Or did you have?
Yes, Judge. So he was arrested on a VPO on the 30th. The complainant
30th of
August. On the 30th of August for a VPO violation. So for them, for it's a bit, shall I say, unfair for him to be rearrested on a VPO for the day prior to the day he was arrested for the same VPO.
Well,
He spent 2 weeks in jail.
No, but they're different, right? So read me if you don't mind, the VPO on 8/31.
Yes, Judge. So on 8/30, an officer was dispatched to a suspicious person call at the listed address in Harris County, Texas. The complaining witness had an active protective order stating the defendant could not be within 200 feet of her residence. On that day, defendant was walking on the sidewalk in front of her house, which is less than 50 feet away from the residence in Harris County, Texas. The complainant had a picture of the defendant on the sidewalk across the street from her residence within the 50 feet. Listen to the protective order.
So, and that was on August 31st,
30th.
30th. This new case that we have here now, this is from November.
It was filed in November, but it occurred on the 29th. So it's just
okay,
a late
hold on.
filing. That's kind of the confusion.
I see.
And on the 30th, Judge, the complainant actually went up to the
Okay,
police
so
station.
here's the, I don't understand what really, I mean, okay, so here's what it looks like. The first VPO that we have here was for the August 30th case. So what it essentially looks like is we have 2 VPOs happening one after one day and then another one happening the next day. But it looks like I don't understand why,
It's
but
different filing officers. So, I mean, in the first VPO that he was convicted in, the officer filed it the day after. He filed it on the 31st. For some reason, they sat on it until 11/26.
hey, guys, your camera. Yeah. So this new case happened 8/29 versus the one that he pled to in September happened on 8:30. So
He
this is
pled
like
to-
what she's saying, it's a late filing, and it happened the day before that other VPO. You know what I mean?
So I'm reading the DIMS and it actually, so the mom went the next day to the police station to complain about yesterday. That's what I'm reading on the DIMS. She goes to the police station and she says, hey, he's been to my house. He went to my house yesterday and now he's on the crosswalk. So essentially they, on both of the DIMS, they're adding 2 of these days on the same thing, on the same DIM. So she's complaining 20th and the 30th.
We have a 911 call from the incident on the 30th, and it says the officers were dispatched to the house. So I don't believe it was a walk-in report.
I'm literally looking at it and it says that she came to 1200. The complainant appeared at the Houston Police Department Family Violence Unit located at 1200 Travis, and she stated that her son stated the defendant was her son.
Yeah,
I'm reading it.
that's my mother.
Don't,
Mr.
please.
Brazil, hold
Have
on.
someone on your
That's for the
behalf.
most recent VPO. I'm talking about the original VPO. There's a 911 officers were dispatched. The one on the 30th.
That's what I'm saying. On August 30th, 2024, the complainant appeared at the HPD on 1200 Travis, and she complained about yesterday, the 29th event and the today's event. I don't know if there's a today event, but
So, okay, it may be so, but they're 2 separate offenses, right? Maybe she's complaining about it at the time. She's complaining about 2 different things, right? Because they're happening in successive order. But I guess technically to the filing, and there's still 2 separate incidents that occur. Are you saying you're saying it should just be one VPO and not 2?
I think I figured it out.
Okay.
Yes, she made a walk-in, officers were originally dispatched. She made a walk-in report and she told the officers that the defendant went over to her home wanting to fight her boyfriend. The complainant stated the defendant left when he found out her boyfriend was not home at the time. That's the VPO, or that's the violation that happened that he pled to, I believe. And then the defendant returned to the home to try to fight the boyfriend. That's when the Berghav and the second VPO happened. So these are 2 separate trips to the house. It's just the filing's messed up.
You need to talk to your lawyer, and then she can.
no,
So-
I'll explain to you, Mr. Bezel. Don't worry about it. So essentially, there are 2 different days, even though they happened the one day after the other. She complained the second day about both of those incidences. That's when the officers went to the house to arrest Mr. Brazil, which I think is confusing because if she's complaining about him coming to the house the next day and they go and arrest him that same day, then it's essentially both VPOs should have been filed at that time.
I think I need
Once
to
again-
call the officer. I'm not prepared to make any, decisions on these cases
Why
right
don't
now.
we do this? Let's roll it to tomorrow. Are you okay with that?
Yes, Judge.
This gives-
Mr. Brazil, he's here on the Berghav anyway, which he has not made bond on, so he's still here.
Well, that's true. So you've got the open felony case regardless. So let's do this. We can roll you to tomorrow. This gives you the opportunity to speak with Ms. Oko. She can do the research she needs to do. It gives more time also to your lawyer to do any other research that she needs to do, and then we can get together tomorrow. And don't. I know you have to understand that anything you say, they're going to use it against you. I know that you're trying to help, and I've seen so many instances where someone tries and they think that they're helping themselves, and then they end up admitting something they shouldn't say, and it helps makes the case. Okay. So what we'll do is we'll have you put you back in back. I'll have Ms. Oko reach out to you. You guys powwow. We'll bring you back tomorrow, and then we'll see what. Yes. Yeah. I'm going to have her call back over there right now so you guys can talk. Okay. Yeah. I know that you're itching to talk to her, and we're going to get you right now. 2 minutes. There will be. We will be. That's what we're here for. We're not here to play.
Visit PC, Your Honor. I have some questions.
Oh, you picked up a new case. I'm sorry. I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading. And now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay,
Pursuant to the, I guess,
I understand.
that we literally had one after the
Understand.
other, like a rung on a step ladder. One. After. Yep.
And-
So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
my understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe,
So,
but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. And they're
I understand that.
a 0.1 mile away from the location. For
So,
what?
well, okay, I get that. But so we have what we have. We've got a disturbance at HEB. Cops go there.
Okay.
They start to talk to him, and I guess at that point says, "Hey, man, I'm going to slap her." So at that point, I mean, that's what we have,
Okay.
right, Mr. Zenon? There's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
It's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, all right, hold on. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly, they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know? If,
they didn't,
Hit.
they took the one that I do not believe applies here.
let's read the code.
Okay.
Let's see what the code says, because, you know, there's multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, it's 3815.
That's okay, don't worry.
You're right. It could have been like a resisting, you know, but. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
you.
the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open
away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all
They
described
put him,
the
I guess,
defendant.
did they put him under arrest at the time when he said that he was making that threat?
And with being
I mean, did they
0.11.
have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under arrest.
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist. That's not interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate with, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. It's if the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's,
Okay, well, I mean, but so
I mean,
this
we
is,
don't know. I mean,
okay, I'm just saying.
if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is,
We also
And
don't
yes.
have the offense report
We
yet.
don't
I
have
Judge.
don't care. I mean, but I think that there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I see- I know, but I don't have the video.
I
I've
mean, I
shared the
think that-
videos with.
Remember-
Right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, you know? Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you are disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I got to say,
Required 3 times to search me.
can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find,
Because I
if
want
you
to
find a
walk out.
completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay, well, then
The
address it.
bond right now is set at 2,500.
Okay,
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, and I don't know what we need to do to get your attention, man. In life, if you're with a person that brings the worst out in you, then don't be with that person. There's a gajillion and one fish in the sea, but how can a person get you so wrapped around your finger to make you, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend, Judge, and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set tomorrow, Monday, what in?
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want, surely. Do you have it?
We have the camera, or the body camera.
I just shared.
Okay, so
They shared it, they just shared it with me.
let's roll it tomorrow. You guys take a look at the video as well, be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause and then we can regroup again tomorrow.
Okay, thank you.
Okay, all right, Mrs. Zenon.
Hey, come on.
See you tomorrow.
See you tomorrow.
I'm not happy with you, Mr. Johnson. You're on bond in this case, and now you've picked up a felony case. The only thing I asked you to do, behave yourself, don't pick up any new cases. And now, Morgan, what has Mr. Johnson picked up?
Unauthorized possession of a catalytic converter.
Wow, what happened? Please.
So officers were dispatched to an apartment complex. The security guard in the apartment complex observed the defendant. Observed in plain view in the defendant's vehicle 3 catalytic converters that were freshly and jaggedly cut. The defendants were not mechanics. There's 2 defendants in this case. Defendant 1 was under a vehicle cutting the converter. When he saw security, he attempted to escape by jumping into a vehicle where defendant 2 was in the driver's seat. Security stopped them from leaving.
So where was Mr. Johnson?
I'm just trying to figure out if he was the number 1 or number 2 defendant, Judge. 1 second.
Right, where was he? Was he in the car? How do we know if it's him? I don't want to try the case, right? But I don't want to.
Sorry, Judge, in the DIMS, they just identified the defendant 1 and 2. Let me just pull up the offense report really quickly. Okay, so Mr. Johnson was under the car. He was the defendant that was under the car, and then there was another defendant in a waiting
So
vehicle.
was he in the act of taking another one?
Yes, he was in the act of trying to steal a catalytic converter when the security guard caught him.
I am now going to revoke your bond on your first case. I asked you not to get in trouble. You've now picked up a felony case. Is there anything that you would like to add?
Your Honor, I would ask that the court set a bond and obviously.
I mean,
I understand. Yeah.
That's, each one of those is like $5,000-6,000 and someone has to. Life's hard enough as it is, man. You know, really. It goes with you. Hi, Ms. Sigler. Good morning.
Hello, good morning.
So it's making a firearm accessible to a child. Did someone pass away as a result?
So this one was the defendant, the father of the children. There were 3 children playing. And then the gun or the weapon was found on the bed, and one of the children was trying to get rid of the gun and then ended up shooting and killing his 10-year-old brother, shooting in the side of his head. And I spoke with Caroline on this, but I was more comfortable deferring to you without an agreed rec on what you thought was appropriate here.
I don't know.
I looked at the
You know-
mitigation packet, but
What'd you think?
for some reason, the case is 2 years old and it was only a 7-page packet. I felt that his statement wasn't really, taking as much responsibility overtly for this. And then it was images of their family. I understand all of that, but with 2 years going on, I don't know why this wasn't resolved with the other chiefs or what's going on, but I just wanted to see a little more with it.
Mr. Gutierrez, come up. Come up. Oh, he doesn't speak English.
No.
Got it.
Morning, Judge.
Hi, Luis, how are you?
So you wanna,
So are you okay with going without an agreed rec? Ms. Siegler? Are
Sorry.
you okay with going without an agreed rec? Where was the weapon initially? Do you know?
It was found on the bed.
fue encontrada en la cama.
Just a gun is laying, a gun is just, well, I mean, do we know where it was initially before it was used? I guess that's my question.
There were several guns in the house. If you, one moment, let me pull up the OR, but this one that was involved in the accident was found on the bed. One second.
Un momento.
The mother, the complainant, or sorry, next of kin advised that she was told that one of her children was trying to make the bed and in the process moved the firearm and it was discharged. And the child did not know that the gun was loaded.
The worst, that's the worst nightmare.
I know.
Just, it's awful.
Terrible.
I don't know. I don't. I think that there has to be some punishment, right?
Your Honor, we're happy to speak to him and have him redo his mitigation package.
But the thing is that he's had the chance to do it. You know what you're supposed to do. And if you can't own up to it at that time, then, I mean, that's truly what you mean at that time. Right? So I'd like to see it, if you don't mind, his letter, to see
Of course.
how he feels. Is he truly remorseful? You know, because, you know, on one end, I would think that the fact that your own child is dead because of you, is that punishment enough? Right?
That's where I was at too, Your Honor, which I was conflicting on.
If you can't even take responsibility for it, I mean,
And
You
the
know,
next of kin, the mother, the prior chief did speak with her in person. We followed up with her over the phone. And she has expressed they've all been to therapy, obviously, and she said to leave it up to us.
are they still together? Are they, is the family still together?
Yes.
So let's do this. Let's get the plea done. I'd like to get it done today. It's 200 days old. Do it. There's going to be some. Okay? Not as much, but there's going to be some. And then, but then I'd like to see his letter first, though, if you don't mind. Okay? And then,
This is in Spanish, so.
it's okay. I can read Spanish. And then, do you want to go ahead and write it up and do it today? Or do you want, tell me how you want to do this.
I would, whatever the recommendation is, I would like some time to talk to him about it.
Okay.
And if he would like to take it today, then we can take it today, but if not, then I would ask for something.
No, if he doesn't take it, we're going to set it. It's 200 days old. It's time. So I guess let me take a look at the letter. Let me read it and then I'll get back to you. And then give me 15 minutes. Let me just talk to them and then, okay?
Absolutely.
Okay.
Thank you so much.
Sure.
I'll print it right now.
Thanks. Hi, Will. Shh. Mr. Trevor Maines, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. Oh, guys, crap. I'm sorry. Sorry, John D. And thanks, Mark. This is Mr. Trevor Maines. It's the last name, Trevor Maines. I guess under Trevor.
Sorry about that, Judge.
It's okay.
So officer, are you ready for me?
Yeah, okay. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers were dispatched to a bar in Harris County, Texas, in response to a suspicious person. The complaining witness, a security guard, told the officer that the defendant had left the bar and gotten into his car, but then returned a short time later carrying a gun. While there were other parties arguing in the outdoor area of the bar. The defendant took the gun and threw it under the fence. The complaining witness retrieved the gun, took the bullets out, and returned the gun to the defendant and told him to leave. Complaining witness then observed defendant go to the back of the bar and hop the fence to get back inside.
So they had told him to exit the bar, you said?
Yes, Judge.
Okay. Mr. Trevor, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
7.
What do you do with yourself these days? What do you do with yourself these days?
So unemployed, I don't have a job.
How come?
Just moved here. Moved out here.
From where? Okay. What are you planning on doing with yourself?
Job.
Okay. How long has it been since you've had a job?
Like 2-3 years ago.
2-3 years since you've had a job? How do you support it? How do you live? How do you eat? How do you get money? Okay.
Trouble. See my record. I don't be in trouble.
Does he have any prior criminal history?
Just carrying a handgun in a motor vehicle that was dismissed.
I'm ordering you as a condition of your bond not to go back to this place. Do you understand? Not to be in possession of any weapons. Do you understand? So how are you going to get a lawyer, sir?
Pay for them.
So you're just going to do nothing and
You sign me a
so I don't want to talk to you, the case. I don't want to talk about the case, but let me ask you this. You haven't had a job for 2 to 3 years. Why should the people of Harris County have to foot a bill for you when you get to do nothing for 3 years? How is that fair that we all have to pay for your lawyer when you don't do anything? You get to play Xbox all day, just hang out at home and do nothing, and we have to foot the bill for that? How's that fair?
I don't have it. What you want me to do?
So here's what we're gonna do. I'll have you fill out an application. I'm now making a condition of your bond. You've got to get a job. And I'm gonna bring you back in 2 weeks. I want to see what you've done to get a job. You're 27 years old, dude. This life is really, really tough without money. And the older you get, life doesn't get easier. It gets harder. You get bigger, you get fatter, you get uglier, you lose hair, right? And if you don't have a job, if you don't have a trade, if you don't have a way to make money, what do you think is going to happen? Do you think people are going to keep giving you handouts the rest of your life? That's how we have all these people who walk the street looking all Quasimodo-like, have no way of getting money, no traits, no skill. That's not the way to go through life, man. Now is when you work your ass so that when you become 60, when you become 70, you have a cushion, you have somewhere to land. So you have a house, you have a nest egg savings. Because if not, I'm going to tell you now, you're going to have a really rotten and miserable life. This life is a journey, and it's really a good journey where you buy nice things, have nice clothes, take nice vacations, pretty wife, kids, or it can be a rotten toilet of an existence where you're in and out of jail. You ain't got no money. You're begging every single person for this and for that. And that's not the way to go through life. Did you even graduate from high school? I want you to get a job. I will give you a lawyer today. But you're not to use alcohol. You're not to use illegal drugs. And I'm going to test you like crazy. I want you to know that now. And I'm going to hold you to a standard as well. Do you understand? And if you don't, life's not going to go well between you and I. I'm just telling you that now. You will be held to a standard. I'm going to bring you back in 2 weeks. And I want to see what you have done to get a job. If you come back here and you ain't got nothing in your hand, it's not going to go well. Do you understand? You might give an application. All right. Good morning, Mr. Daly. What would you like?
So Judge, two things. I've talked to Madam Prosecutor on this case, Judge, and I'm approaching on two things. One, bond reinstatement, and PC on this case, Judge. She and I have already discussed it on this case, and we just both want you to hear the PC if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide.
Traveler? Okay.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Okay. Tell me what.
So we looked at, I'm sorry, Madam Prosecutor, the interference with duties of public servant, Your Honor. Even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However, in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
They're just trying to get him out of the car.
I don't
And
disagree.
It's classic sovereign case where got the license plate, think that traveling by right is what I think how they term it.
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
But he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos, and go on YouTube, right? There are hundreds of videos where officers will literally destroy your car to get you out. When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Daly?
We don't disagree, Your Honor.
Right. You know what I mean? That's real life.
We don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know, did you hear that on the video? Right. And so in reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor. In this situation, it wasn't as if he was intentionally
Remember,
not.
this is just a mere probable cause.
Yes,
So,
Your Honor, I agree.
they ask you to come out of the car one time. Yeah, it's really, so, I think that there's enough probable cause to go forward now. The problem is, Mr. Daly, is that we revoke your bond. Your bond is set at 2501, and you've continually failed to appear. So, the case and the way that you've treated us, it shows me that you just refuse to accept authority. How are we supposed to deal with that? How do we deal with that, Timberland?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration, we have a Black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system. And from what I can see and what I hear out here from a lot of my Black male, and I'm sure it's common knowledge, is that because they are unfamiliar with the court system, they don't know, number one. Number two, when they do come in contact with police, and my mother is assistant chief of police, so I can understand, even when I was younger, I was taught that there are certain things that you have to do with when a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a police officer as a parent, or who isn't familiar and is being raised in this particular climate and seeing what they see on TV and seeing what they hear and everything that has occurred, you don't know what the proper steps are. I was trained from when I was grown up, what you do. I'm not saying that what he did was right or wrong. I'm not saying that how he reacted to this particular court, it is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration, number one, from his perspective, all defendants, can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now on the case. What you know about me, I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I'm not going to do this again, though. I promise you. I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? I mean, when you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
No, right now.
You're not allowed to drive.
Right.
You have a bond condition and you've signed an affidavit with me today promising you're not going to drive. I don't care how you term it. Driving, traveling, however you're going to word it, whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road unless you have approval from us. Do you understand? I don't care that you have to work. I don't care if you have to go to church. I don't care if you're going to a funeral. I don't care if you're going to wherever it may be. Do not drive. Do you understand? Heed this warning. You're not going to get another one. Okay, Timberlake, I'll reinstate the bond.
Thank you, Your Honor.
And
I'll talk to her. We were going to try to talk to Chief, but it's pretty busy
I
today.
think the case is only 3 months old,
Yes,
so
sir.
you've got time. You can do whatever you want.
Yes, sir. Thank you, Judge.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court now, but you must stay in touch with her and she'll tell you when you got to come back to court. If she comes back and tells me she can't get a hold of you because you're playing games or you've gone AWOL or whatnot, or you get arrested for something else, all bets off. We good? I'm not asking for much, man. Really. And for future reference, when you get into a pissing match with someone with the power of arrest, you are nearly always going to lose. It's just the way it works. And as a young Black man in today's society, you got to be extra special careful because things can go really wrong really quick. And there's evidence of that over and over and over. Okay? All right. Good luck, guys.
Thank you, Your Honor.
Yes, ma'am.
Thank you, Judge. Go ahead. Thank you. Thank you. You want to show this to Chief?
Yeah, I just sent her.
Thank you.
Of course.
You're Stephen Benito. Mr. Benito, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On 4/29/2024 in Harris County, Texas, officers observed a vehicle run a red light and they attempted a traffic stop. The vehicle evaded for 0.59 miles, speeding 63 miles per hour in a 30-mile-per-hour zone before crashing into a tree. The driver detained the defendant got detained and was sent to Woodland Memorial Hermann Hospital for his injuries. Officers recovered a bag from the vehicle containing a firearm. So he ran a red light, they attempted a traffic stop, he evaded for 0.59 miles, and then they found a firearm on him.
Where was it? Don't say anything, please.
He was traveling southbound in the 29800 block.
No. I mean, like, where was the gun? I guess, yeah. No, it's a accompanying felony. Mr. Benito, I'm going to find that the probable cause is I'm going to find probable cause to go forward with the case. How old are you, sir?
He was inside the center console.
17. What do you do for a living, sir?
Not work.
Are you in high school?
Online school. Online school.
What does that mean?
Yeah, I'm enrolled in online school.
Okay, I'm sending you for a drug test. And I don't want you to smoke weed. I don't want you to use alcohol. I don't want you to have any weapons. Do you understand? Do you have a Texas driver license? You're not allowed to drive. You will be signing a promise with me today, Mr. Benito. I want you to understand that I take it extremely serious. You are only 17 and you're starting your life out now. You have an open third-degree felony. You're looking at up to 10 years in prison. This is not a good way to start life, man. Really. You have your whole life ahead of you, and I'm going to tell you, you end up in prison, it's a veritable nightmare. We're going to do everything in our power to make sure that you go on the up and up. I want you to stay in school. That's also a condition of your bond. Do you understand? I don't want you out in the middle of the night. I'm giving you a curfew as well. I'll give you a lawyer today, but we're going to work hard and fast to make sure that you go on the up and up. You understand? No more weapons and no driving. Who are you here with today? How'd you get here? Okay, don't drive. I'm not asking much.
Judge, it was in the center console. I just need to review the report.
Okay. This is an affidavit. This is a promise that you're going to make to me. And if I find that you drive, and I'm telling you, I don't care what your reason is, I can have a contempt hearing. You can be facing up to 6 months in jail and a $500 fine every time you drive. The problem with driving without insurance, Mr. Benito, is that if you get into an accident, and let's say you kill someone in that accident, who do you think they're going to come after? Right. No, not after you. They're going to come after the deep pockets, which are probably mom and pop. You don't want that to happen. You understand? Come on. So let's send him for a drug test. We'll have him come back, appoint a lawyer now, and then we'll, get with the lawyer to see how we go forward with. Happy with you, Mr. Jones. You've now picked up a third case. You now stand charged with failure to identify oneself. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 5th, 2024, officer initiated a traffic stop on defendant's vehicle for failure to display a front license plate while he was driving in the 5900 block of Mercer Street in Harris County, Texas. Officer made contact with the occupants and detected an odor of marijuana emitting from the driver's side window. All three occupants were detained for a PC search. The defendant provided the name of Kendrick Johnson with a date of birth of 8/30/2006, which returned with nothing. Officer used a mobile AFIS device and found defendant's real name to be Jamarcus Jones with the date of birth of 8/30/06.
I ordered you as a condition of your bond, and you promised me when you got here last time that you would not drive. Stop. Did you say that he was a driver here? Stop. Don't say anything. I don't want you. Don't. You have the right to remain silent. Exercise that right. I was under the impression, Rosette, that he's driving here. Is he not?
There were three occupants in the car, Judge. I'm trying to see if they clarified. He was a passenger. He was the front passenger, Judge.
Okay, so tell me, let's do a deeper dive.
Sorry?
Let's do a deeper dive. So they pull him over. He's the passenger.
There was an odor of marijuana detected.
So what happened next?
So they detained all three occupants for
Okay.
a probable cause search.
All
The
right.
driver was identified by his driver's license, and the front seat passenger, which is the defendant, provided the name of Kendrick Johnson. And a mobile AFIS revealed that that wasn't his true name. And so he was charged with failure to ID.
Do we have any co-defendants in this case?
Yes, John Burns.
Okay. So what's the cause number on that?
On that one?
Yeah.
It's 25-417-01. That's in court 15.
Okay, is there a third co-defendant as well? Okay. Mr. Jones, I'm glad that you're not driving. Regardless, you've picked up a new case. I don't know what we're going to do, but normally when you pick up a new case while you're on bond, we revoke the bond on the old case. So, I mean, it goes with you. I'm going to appoint your lawyer today. We'll figure out how we go forward. But for now, I'm going to take you in. I'm going to appoint your lawyer. We'll see how we go forward. But you're supposed to behave yourself while you're on bond. You've now picked up a third case. You first have a felony theft. You got a second case, and now you've picked up a third case. It goes with you. Can you please, one number one? Hi.
Good to see you, Judge.
You too.
I'm here on Mr. Benito's case, Benito. Young man got appointed in this case this morning. And he's present here in the courtroom.
Okay.
A couple things, just a little bit by way of background. The state and I have talked about what I think may be some issues in the case. I think as far as a bond condition, he was sent over for testing. I think this is his first appearance here. My understanding is results of the testing came back positive for marijuana. I've talked to him about the importance of not having that issue moving forward. So we're aware of it and we'll address that. I talked to the state about what I think is a legal issue that exists in the case. I don't know that it exists from a probable cause standpoint at this moment, because I don't know that the officers had enough in the way of developed facts. The interesting issue is our chapter 4602 statute about unlawful carrying of a weapon does not apply to a person who is traveling under the code. But I think that requires some factual development that was not within the officer's purview at that time. So I won't belabor the court with all those details.
Okay.
He's got the felony charge that's still pending. But we're aware and will not have.
And I think it's did you say it's 0.5 of a mile for the evading?
It's about a half mile. Yeah.
Okay, I thought it was something like 0.5. You said something like that. All right, Mr. Benito, we're not asking much. Don't use marijuana. I'm telling you now, you will be tested in 45 days. If you continue to use, what happens?
You understand, Judge?
You understand? Okay, I'm not asking much. Stay in school. Try to be the best person you can. Don't pick up any new cases. Don't drive because you don't have a license, and don't use marijuana. That's it. Were there co-defendants in this case?
No, that I see.
Okay.
Judge, I just put it together. 0.5 is a half a mile. But my math is slow.
They
so-
say 5.
0.59 miles, half mile, a little over half mile.
Aye. Okay. Be good. It's not hard. Okay.
Yes, Judge.
All right, kids.
Thank you.
Have fun. Come up, Mr. Jones.
Mr. Nayland is in Cancun until Monday of next week, Judge, so he's not available this morning.
I
So I'm kind
understand.
of filling in. I have had a chance to look at this violation report regarding Miss Blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
It says 19, Your Honor. That's 7, within that 7 or 8. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm
hear-
sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all, cold weather. I apologize. So can I please speak on the breathalyzer?
No.
Just
You
told
know
me
what
last
the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please.
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate, for alcohol.
I go to sleep early, man.
Test. And he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
Then you come here and you ask.
Oh, they just told me about this last week in pre-trial over there, and they said that I have a 45-day miss.
Yep, 19 missed blows, dude. Covering the camera.
Please, Honor, I will do anything. I'll even go on that drug, ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I'll do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor, it's just, I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond further?
Of course.
Oh my gosh. Your Honor. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine. Because, fine. All right, Mr. Trevor, do you mind getting a cell phone, please? Do you have a pen or do you need one? I need your cell phone so I can give it to the lawyer. If you look on the TV, that is Mr. Gregg, who's been appointed to represent you. Your cell phone, please. It is your responsibility to stay in touch with him, Mr. Trevor. Thank you so much. It is your responsibility to stay in touch with him. You know what the expectation is here. Do you understand? Yes or no?
Yeah.
Okay. I'm not asking for much. I want you to be the best person that you can be. Believe it or not, we want to help you. We want to make sure that you amount to something in this life, not just do something, man. Do better. Be better. If he tells me he can't get a hold of you, if you pick up a new case, you violate conditions, I'm going to revoke the bond. It's very possible you will not get any more PR bonds. Do you understand? You got out of jail because you were given a free bond. But for those who are dangerous and for those who continue to violate laws, they usually do not continue to get PR bonds. I want you to know that. And I want you to know that we're going to protect our city at all costs. So what we'll do now is, have we had him sign a reset yet, Victoria? Mr. Trevor? Okay, so we'll just have you step outside. You'll be able to talk to your lawyer, and after that, you'll be free to go. All right. Okay, man. Greg, did you want to say anything?
No, just call me. We'll speak about your case. I'll look at everything. Was PC found already, Judge?
Yes.
Okay.
There it is.
I got his number. I'll shoot him a text right now. And then
I chatted you his phone number there. His phone number will be on your reset so that you will also have a copy of it as well. If you ever have any issues, if you lose your paperwork, if you're unable to get a hold of him, if you ever have a problem, all you have to do is come back here and we can help you out with whatever you need. If you need resources, whatever it may be, come back, ask, and we can help you out. But communication is key. If you don't communicate, we just can't help you. All right? Okay, man.
Judge, how much time did you want on that one?
Good morning, Mr. Colegio. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 30 days in jail, credit for the 12 days that you've done. You need to understand that this is going to go on your record. It's going to be there for the rest of your life. What happens next time?
I won't be here next time, sir.
If I had one strand of hair every time someone told me that right there, I would look like you with hair. Really. If I had one strand. You need to understand that both of these are going to go on your record. They'll be there forever. Even if you have a sip of alcohol, if you get pulled over, an officer's going to see DWI, 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 they're going to probably take you right in. From now on, you're facing a 3rd-degree felony, 2 to 10 in the penitentiary. Do you understand?
Yes, sir.
So I wouldn't get in the car even if you've had a sip of alcohol, because if you thought this was bad, wait till you get to felony court. You're giving up the right to a trial, right to compel witnesses. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it goes on your record. You can never take it off. You understand?
Yes, sir.
You still want to do this?
Yes, sir.
How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
It's alleged that you had an open container. Is that true or untrue? Did you have an open container of alcohol in the car?
Yeah.
I did discuss that.
I'm going to abandon the second enhancement, but that's an enhancement that makes it a minimum of 5 days in jail to the case, which you've already satisfied it, obviously.
Okay.
But it's still an enhancement that they have on there. They actually have 2 enhancements. Your second enhancement is one that you had. Actually, there's 3 enhancements, actually. So it's also alleged here that you had a prior DWI in County Court 5 in Montgomery County. Is that true or untrue? It's also alleged here that you had a 0.15 or above. Is that true?
I would, due to the actual results, I would ask them to abandon that one.
Okay, I'll abandon that one. I got to look to see, because that one might make it 90 days though.
The NCFC code has to change. Because it's a DWI second with the 0.15.
It's a second.
With a 15.
Okay.
So we need to, so.
Because it is a 0.14 and a 0.15, so I would.
Do you know what the new NCSC code
It
is?
will be just a DWI second, right?
Yeah. I don't have, do you guys have the NCSC code for just a DWI second?
Yeah, I think it should be the 14.
I don't know. I want you to understand that there's another big thing about this, Mr. Colegio, that DWIs are big business in Harris County. You know, this right here, there is a $6,000 surcharge that goes on you because this is a second offense, plus court costs of around $500. So, because you're in custody now, I'm gonna end up waiving it because you're in custody now, but the more DWIs you pick up, the worse life gets. And it's so easy. All you have to do is hit one button on your phone, $40, and Uber will take you wherever you want to go, man. Don't get into a car again if you've had alcohol, because it's not gonna end up well. Did you find a chance?
Yeah, yes, Judge. I think the paperwork may have to be refiled. I'm not entirely sure. But she's gonna work on it.
Are you okay with abandoning the 15 enhancement?
Last name again?
Colegio, COLL.
EGL.
So then what we'll do. And what's the logic behind that?
Well, one of my fear was that it would make the minimum higher, but
Don't worry about it. Don't worry about it. Pretty high. That's why I was, that's what my understanding was. I didn't know that. Mhm. That's scary. That's why I kept it, and it's minimum was 3. 30 is why.
Okay, so I just say it.
you would, yeah.
Okay.
Your breath.
Okay, yes, sir. That's
So we can continue with the plea as written.
Okay, so is it true that you had an open container? Did you have an open container?
Yes.
No, you were there.
Yes, yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Okay. Is it true that you had that prior to DWI?
Yes, sir.
And it's also true that you had a 0.15 or above?
Yes, sir.
Okay. You know how to act. You know what to do.
Yes, sir.
Just be good in the future. We're not asking much, We want our streets safe. How do you plead to the offense? Guilty or not guilty?
Guilty, sir.
Find you guilty. I will follow the agreements. For cost. So I'm going to waive the DPS fees. I still need that order, please.
Yes, we'll do it.
And then I am going to suspend your license for a year. Do not drive. It's a DWI. It's a second DWI. You're
Okay,
pleading
yes, fine.
guilty.
Thank you, sir. Thank you.
That, look,
Fine, thank you.
you're going to get out of jail.
Okay, can I get an ID, like a regular ID to start working?
Well, of course you can.
Okay, I'm just asking. That was the reason I turned myself in.
Glad that you did.
Thank you.
You're getting out of here probably today. When you get out, don't start driving.
Yes, sir.
Call DPS. They can tell you how to get your license back. And then when you do things the right way, good things happen. If you go out there and you start driving, even though you got to work,
Yes, sir.
Murphy's Law, what can't happen will happen. You're probably going to end up getting pulled over and you're going to be right back over here. So do things the right way. Good things happen. All right. Good luck. Thank you. Thank you.
Yeah, Ben heard with me last week. I was in Cancun. I guess there's a TBR for positive alcohol.
He's out now. Don't want any more issues. Just. Don't want any more issues. I'm not asking much. Just do what you need to do. Really, you know?
Judge, pretrial, if I talk to pretrial, they said they're gonna, they list me about the THC or I don't know what you wanted.
God, it's only 70 days old too.
So Judge,
All this trauma and it's only been 70 days.
is that it? The lab is back. There's no alcohol, which we expected that already. We're still waiting for drug analysis, but I think as soon as that's back and the state's ready, we just either just try it or, just try it. Let's get done.
Is that where this is headed?
Well, I looked at I've evaled it, and I don't think it's the DWI. I don't think it's intoxicated when I looked at the eval, but but the state can't do a full eval until they have their labs for the blood. And
Tell me what you
I
think.
expect that.
I mean, I'm going to tell you now, this has so much drama, Ms. Saba, that I'm like ready to pony it up with Justin as well. You know, I don't want to sit and wait another 6 months. And,
Judge, we don't,
oh, that's wonderful. Hi, you look great. You know,
what were you?
It's gonna be an alleged drug case.
Oh, yeah, we
Is there a
just don't
DRE
have the
done?
toxicology report
DRE?
yet, Judge.
I can't hear. I'm sorry.
DRE, shh. Was there a DRE?
DRE? Yeah.
We just don't have the toxicology report yet, Judge, so, and the case is only 2 months old.
I know. No, well, yeah, a little bit over, but yeah.
A little bit over.
How long do you think it'll take?
I think it should take one more month, because sometimes I've seen them take up to 4, but maybe we can give it like one more setting before we.
Yeah. Okay, we'll sit you off 30 days.
Still have them come in to do drug testing.
Yeah, just don't use, you know? All right, so we'll continue supervision now, Felicia.
Judge, just to clarify something, so you are permitting the usage of THC?
No, I don't,
So that's like, there's no limit here,
I know.
so I don't, because we're just gonna continue about, we have to.
Yeah, I mean, how do we deal with this? I don't,
Let's hurry, get the labs back and
Yes,
eval it and try it.
I'm not down with you continue to use marijuana. I'm not down with it, Mr. Jones. I don't want you to use. There has to be an alternate method to dealing with issues.
See a doctor and all kinds of stuff still though.
Yes, yes, that's what you're supposed to do. You're not supposed to self-medicate.
He's not self-medicating. He's got a prescription for marijuana. And I know we've gone down this road already. So he's not self-medicating. He's under a doctor's orders.
He has a second DWI that's open. I don't want you using, Mr. Jones. Just the plain and simple of it. I mean, don't. Do you understand? Don't use and get ready, please. It's way too much drama. I'm ready to put this baby to bed one way or the other.
We'll reach out to the lab and do an
Please.
eval.
All right, I'm going to do 30 days. I'm going to continue it now. Don't use. You've got 40 days. Do you understand? Yes or no?
Sir.
Okay, get ready. All right.
Stop right there, because what you just watched inside this courtroom raises questions most people never have to answer. A father stood before the judge on a charge that no parent ever wants to hear, making a firearm accessible to a child. His own son found a gun on a bed, and in trying to move it, accidentally shot and killed his 10-year-old brother. The case sat untouched for 200 days. The family, somehow, is still together. The surviving children are in therapy, and the judge, before deciding anything, asked to read the father's letter first. He wanted to know one thing. Was this man truly remorseful, or just saying what he thought the court wanted to hear. Then came the question that silenced the room. Is the fact that your own child is dead because of you punishment enough? There is no clean answer to that. Is criminal punishment about accountability, deterrence, or is it the law simply saying, society still has something to say, even after a family has already lost everything? Then there was a 27-year-old who walked in with no job, no plan, and no real explanation for how he'd been surviving for the past 3 years. The judge didn't hold back, asking him directly why the people of this county should have to pay for his defense while he does nothing all day. But instead of turning him away, the judge gave him a lawyer anyway, with one condition: get a job, 2 weeks, come back with proof. A young man on his very first weapons charge found himself detained after fleeing a traffic stop that ended in a crash, a firearm recovered from the vehicle. Only 17 years old, already facing a felony that could follow him for the next 10 years of his life. Another defendant sat in a courtroom drug testing update, breaking down completely, pleading, swearing, begging the judge for one more chance after missing 19 drug tests. The judge listened, and still had to say no. And then, one of the most quietly devastating exchanges of the day, a man accused of assaulting his partner, kicking her while she was already on the ground. The judge made it clear, this court will use every tool available to protect the people in this county, regardless of who stands in front of the bench. Every one of these cases moved through this courtroom in the span of a single morning. Grief, addiction, poverty, fear, violence, all of it, processed one probable cause hearing at a time. This is what actually happens behind the bench. We'll see you in the next one.